All right, well, as news from Maryland this week, on the other end of the spectrum, it demonstrates why we've got to continue to pray, we've got to continue to vote, and to stand up against the left's takeover of our schools. A U.S. Court of Appeals dismissed a case that would have prevented Montgomery County schools from concealing students' gender confusion from their parents. Folks, you heard that right. We now have a major court saying the school has the right to keep information about gender confusion from the parents. The district has what they call guidelines for gender identity that state that if a student identifies as a different gender at school, teachers should hide that information from parents. And according to the appeals court, because the parents in the lawsuit supposedly did not have children who identify as transgender, the court said they had no standing. Well, that seems to kind of totally miss the whole point to me. But nonetheless, joining me now to discuss this is Stephen Fitschen. He's the president of the National Legal Foundation and was a co-counsel on this case representing the parents. Steve, welcome to Washington Watch. Glad to have you.
Thanks, Jody. It's good to be here.
All right, so I'm sure you're disappointed with the lawsuit being dismissed, but explain what the parents were seeking and what the courts actually said.
Right. So you explained the basics of it. They adopted this policy going back to the 2019-2020 school year, and they do hide this information from the parents if the school decides that the parents would not be supportive of what the child is trying to do. And it applies from high school all the way down to kindergarten. So you can just imagine, a kindergarten kid, a fifth grader, an eighth grader says, hey, I want to be the other gender. And they do two things in particular to hide it from the parents. They refer to the child by the preferred pronouns, the preferred name, and it's all in files, but they have a secret set of files that's not a pejorative. It is literally a second set of files that they do not give parents access to under federal law. They let them see everything else, but not this. And the second thing they do is when they're talking to the parents or when the parents are on campus, they revert to the given name and the birth gender in front of the parents, so the parents never know this is happening.
Well, Steve, how in the world are the parents supposed to know? I mean, if parents don't have standing, who in the world does? Yeah, I look at this and I say, all right, they said the parents didn't have standing because their kids were not identifying as transgender. How did the parents know whether their kids were or were not identifying as transgender at the school if the school's not going to tell them one way or the other? How in the world is a parent supposed to obtain standing when all pertinent information is being withheld?
Well, that's the heart of the matter. And unfortunately, we had a dissenting opinion, which we'll talk about in due course, that said exactly that. How in the world are they supposed to know this injury is impending? It's likely to happen. It applies to every child from kindergarten on up, as I just said, and the parents will, in fact, never know if the child says, please don't tell my parents. They have the kids rate their parents on a scale of 1 to 10 as being supportive or not supportive, or fear that they will be supportive or not supportive. And if the school says the parents are not going to be supportive in their sole judgment, the parents will never find out until it's too late. And so that's exactly why we said they do have standing. That's exactly why the dissenting judge said the same thing. And so it is just a head scratcher.
It really is. It gives every appearance that the guidelines, to me, make it clear that these people think they know more about what's best for the children than the parents do, that they are better equipped to take care of the children than the parents are. And it appears that they're saying the parents have to wait until damage occurs, until their child is in a vicious life cycle that is going to permanently alter their lives. The parents have to wait until it's too late before they can even sue or do anything. How does this make any sense whatsoever?
Well, it doesn't make any sense for all the reasons we both just said. And one of the most shocking things is that the two judges who voted against us, the two judges who said, you don't have standing, which means you're not the right person to sue, you don't have an injury, they themselves acknowledged how terrible the policy is. They said at one point, they said the school board's position is so staggering from a policy standpoint. A few paragraphs later, they said it is perhaps, and judges sometimes hedge like that, but they said it is perhaps repugnant as a matter of policy. And then they turned around and said, but you can't do anything about it.
All right, I'm speechless of how to even respond to that. I mean, I agree with what the judges said, but how do they make that kind of statement and then turn around, as you just said, and say, but you have no standing? I mean, how do you go from point A to point B in that kind of reality check that we know this is repugnant, but how do they get there?
The only way they get there is they applied correct principles incorrectly. So normally you can't say this might happen or that might happen. It's too speculative. You're raising arguments that may in fact never happen. But the difference here is, as we've already addressed, they won't. They won't. And so it's a different scenario. It's a different ballgame. If the school makes it impossible for them to ever know for sure, the only avenue they have is to try and sue up front, which is why we brought this case. And it's exactly what the dissenting judge said in his opinion.
So what is a parent to do right now in Montgomery County? I mean, what happened? What does a parent do from here?
Well, we are going to ask the Supreme Court to take the case. As you probably know, you have to file a petition, and they sometimes say yes, they sometimes say no. They say a lot more often, but we're very optimistic for a couple of reasons. I'll just mention one of them right now. First of all, this problem is showing up all across the country. Right now, these policies that say schools can hide this from parents, or as in our case, they must hide it from parents, they're in 37 states and DC. They're in over 1,000 school districts in those states, over 18,000 individual schools within the districts who are teaching over 10 million students. And therefore, we are hoping that the Supreme Court will say, we need to deal with this.
And what are they teaching those 10 million students?
Well, that's another question. Not only are they doing these sorts of things, but they're starting to have pro-LGBTQ, as some people say, inclusive materials. Sometimes they're trying to get them into health classes. Sometimes they're getting them into, we have learned of one situation where they're trying to get them into English language classes. And so they're teaching stuff that is very harmful, and again, trying to prevent parents from doing anything about it. And then on this issue, they're just flat hiding it with secret records and disingenuous actions when they're in front of the parents.
Well, Stephen, let me just say thank you so much for standing in the gap. What you're doing is exceedingly important, and I know that you know that. But all of us, we're encouraging our FRC family to be praying for you and supporting you. You know, we just had good news on the one hand coming out of Washington, D.C. with these two pro-life students who finally saw justice for being arrested after being discriminated against. And then you just come right to a case like what you're dealing with. Very, very disturbing. But thank you, Stephen Fitschen from the National Legal Foundation. Very, very grateful for your input today.
Thank you. My last comments is just going to be about, they know there's an injury, they know it's repugnant, and yet they say you have to leave court. The dissenting judge called that an abdication of judicial duty, and that's exactly what it was, and that's why we're going to the Supreme Court.